many cases. So please, Giorgio, if you would like to give you, I think you have you brought some slides, right?
Thank you, Francesco. Good afternoon, ladies and gentlemen. In a week time, the 2012 conference of the Comité Maritime International will be opened in Beijing. And the CMI was established in 1897, and its object is to achieve uniformity in maritime law. And the Italian Maritime Law Association is among its 50 members, and its scope is similarly to achieve uniformity in maritime law. At Beijing, many topics will be discussed. A possible revision of the 1999 Salvage Convention, an instrument on international judicial sales, a possible revision of the York-Antwerp Rules 2004, Arctic and Antarctic issues, fair treatment of seafarers, and among these topics, there is also in the agenda cross-border insolvency. This subject was taken being a topical one in view of the quite important insolvencies recently around the world. And the object is to try to consider whether there is an international instrument which may deal with cross-border insolvency. There are not actually very many international instruments dealing with this topic. There is an UNCITRAL model law, and then there are a few bilateral conventions. For instance, a bilateral convention between Italy and Belgium, and an international convention between Italy and Austria, and also a bilateral convention between the United Kingdom and Belgium as well. However, in the European Union, there is a regulation 1346 of 2000 on cross-border insolvency, on insolvenza transfrontaliera. And this instrument of the European Union brings us some uniformity among the European countries. And we will give a brief look to some of the articles of this regulation. Shall I have, yes. The first article is article number 3, dealing with jurisdiction. And the article states that the jurisdiction is established in the country where the insolvent company has its registered office. And so this is very clear provision. And I have to, I think. Then Article 4. Article 4 is on the law applicable to the insolvency. And here again, the law applicable is the law where the insolvency proceedings are opened. Article 5 then deals with rights in rem, rights of third parties on the assets of the insolvent company. And it provides that the opening of insolvency proceedings does not affect the rights of in rem of the creditors. Rights in rem, namely rights such as maritime liens or mortgages or hypothecs, the claims secured by preferred claims. And this is a provision which may be in conflict with some national laws, as we will see later on. Article 15 provides some guidance as far as to proceedings on lawsuits pending. And it provides that the insolvency proceedings on lawsuit pending in another states does not affect the lawsuit pending, and therefore the lawsuit pending is governed by the law of the proceedings where the lawsuit is pending. For instance, if an insolvency is opened in Spain and proceedings are pending in Portugal, then the rules on a possible stay of the proceedings will be the rules established by a Portuguese law. Then, as far as recognition of the insolvency proceedings, Articles 16 and 17 provides that the judgment on the insolvency proceedings are to be recognized in the other member states without the possibility of being disputed. This provision was considered in a case of the European Court, this case of 2006, which confirmed the ruling under Article 16 and 17 of saying that the insolvency proceedings are to be recognized in the other member states. Let us now go to have a quick look to some of the provisions of the Italian bankruptcy law. Article 51 provides that no enforcement can be made on the assets of the company under liquidation after the opening of the liquidation proceedings. And this may be somewhat in conflict or is overruled by the provision which we saw before under Article 5 of the Council regulation, providing that third parties' rights in rem can be enforced on the assets of the company in liquidation. Another interesting article in the Italian bankruptcy law is Article 81, which provides that the contracts for the supply of works and materials, namely the contratto di appalto, is terminated once the company is put under liquidation. The contract for the supply of works and materials is, for instance, the shipbuilding contract. And some clarification perhaps was required as regards determination of contract of carriage by sea. And therefore, the Court of Appeal of Genoa, with judgment in 1992, held that there is termination also as regards the contracts for the carriage of goods by sea, lifetime charters, and therefore termination, all the contracts for carriage of goods by sea are terminated, provided the liquidator does not state otherwise within 20 days from the opening of the insolvency proceedings. Now we will just to complete this overview on the insolvency, cross-border insolvency. We will consider two recent judgments. One judgment from the Court of Appeal of Aix-en-Provence, stating that no arrest can be obtained on the assets of the insolvent company for the supply of bunkers, because the bunkers, although being a maritime claim, are not secured by a maritime lien. And therefore, the Court of Appeal of Aix-en-Provence made reference to Article 5 of the Council regulation, saying that the rights of in rem are not like maritime liens and mortgages are not are not can be safeguarded even if a company is in liquidation. But in this case, of course, the bank supply is not secured by maritime lien, and therefore the Court of Appeal of Aix-en-Provence held that the arrest on a ship could not be performed. And another case is a case considered by, and this is to complete the review on this cross-border insolvency, is a case considered by the Tribunal of Venice, which was to consider the enforcement of a German judgment opening insolvency proceedings as regards a German company. And claimants sought to arrest the ship of such German company in Italy. However, under Article 16 and 17 of the Council regulation, the Tribunal of Venice said that the arrest could not be executed due to the fact that the German judgment was to be recognized in Italy. So this is a brief overview of this of the Council regulation and of this quite important topic regarding cross-border insolvency, which we think should need some international instrument, because of course insolvencies are an international a thing, and which need to be considered in a uniform way all around the world. Thank you very much.
Thank you, Giorgio. As an arbitrator, I've certainly seen this question of cross-border insolvency come to the fore in recent years. Korea Line, for example, and TPC, again in Korea, filed proceedings in the English court to stay arbitration proceedings that were pending there. And also, I think if one reads Lloyd's List nowadays, one sees that there is almost a predictable pattern of companies in financial difficulty going straight over to the United States to file protective proceedings there, and also in the English courts if they're involved in litigations. So it certainly is a very topical issue, and when we come to have contributions from the floor later, I'd certainly be interested to hear of anybody who's had experience directly of this type of problem in recent months.
We should have had Hamish Norton, the managing director of Jefferies from New York, but I got a message this morning, Francesca, I'm stuck on a transaction which I think you'll read about Wednesday. So Wednesday we should read the Lloyd's List and see what he has done. I cannot make it to the conference. Please apologize with the other participants. I'm sick for the late notice, but I think he will have to come next year to tell us about his transactions. Please, Clive. So I think you may want to introduce